Good morning, everybody. Today, I'm glad to be invited from Siambari to contribute with my knowledge and experience to this project and the course within the project. The project is about knowledge and innovation transfer through technology transfer offices for the enhancement of cooperation and collaboration among academic research organizations. This is just a brief introduction about myself. I have a background in industrial biotechnologies. I have made some experience in a couple of companies at the very beginning of my working career. Then I stepped back into the university where I started dealing with technology transfer since it was the year 2008. And I also got a PhD in business and management in 2011. Then basically starting from 2012, I became the head of the technology transfer office at the Politecnico Torino, which is a technical university dealing with engineering, architecture, and industrial design in the northwest part of Italy. And yeah, since then, I always worked on technology transfer and knowledge sharing. I also have been appointed as a member of the Board of Governors of the National Association of Technology Transfer, NETVAL, in 2016, and I am actively participating to some other associations and working groups on technology transfer, both at the national and international level in Italy and abroad. Today, we are going to talk about IP protection, tools and practice. So we will go through these three main sections of our discussion, a brief introduction on the role of technology transfer and the importance of protecting and valorizing the intellectual property within it. Then we'll have a quick review of the different types of intellectual properties and a more deep focus on patents, which are one of the different intellectual properties that can be managed, but probably statistically the most important one and the most occurring one in our practice in the universities. And we'll see a bit of practice and procedures about how to manage, protect patents. Okay, let's start. Why technology transfer is that important? Probably you will have you already have a clear understanding now of the importance and the reason why technology transfer is important, coming from the previous talks and lectures you had. But basically the idea is that our purpose is to impact society positively, hopefully impact society by transferring developing and transferring on the market the new technologies, products, processes, and services which have been developed within the university as a result of the research activities within the university and other research centers, of course, and making them available to the public to improve the human being lives. And of course, in these slides, you have some example of very renowned drugs or medical innovation, but also like Google or Eudora, other kind of innovation more in the digital world. One thing that we can say to introduce our topic today about with the specific focus on intellectual property is that if we look at the company's assets, and in this case we are looking at some statistics coming from an analysis performed on the Standard & Poor's 500 companies, we see that the so-called intangible assets, which are the intellectual property rights, basically, and other not tangible goods that one company can have in its own business, we see that they are by far the majority of the major share of the total value of those companies. That means that intellectual property is very much important within the companies and within our society in general. And the point here is that whenever we deal with intellectual property and intellectual property rights and the exchange of knowledge, what we are doing is that we are exchanging something that once we have given it to another person, to another colleague, we cannot then exclude that person from using it, because at that point, that person will know its content, will have that knowledge, and we cannot erase her or his brain so that he cannot know it anymore. So the only way we have to manage these aspects and protect the value that is within the knowledge we are transferring is by means of rules and conventional obligations that we can take each other thanks to the law system. And this is the reason why this is important, because if you can imagine the situation where an innovator makes a significant investment in developing some new products like this music player, for instance, in the picture, which is a bit old style already, but it was an innovation at its own time. And then we have other competitors of that company that didn't really develop it by themselves, but once they have seen it on the market, sold from the previous company, the innovator, they can just take it, buy one piece, and retro engineering it so that to copy it, to build it, and to sell it to the market, competing with the first one. And the important thing is that since they didn't have to cope with any innovation investment to get to the knowledge needed to build that product and to sell that product, they can probably offer that product for the same price or even reduce the price, putting heavy pressure on the first company, on the innovators. And in the long run, this kind of approach would, of course, demotivate any prospect innovators. Any company would have no good reason to be the first one coming out with a product, because they know that anyone can copy that product and just compete with them without having put any effort in discovering it, inventing it, or developing it. And this is the reason why we need an IP system, which is a system which puts rights over the use of invention, designs, brands, literary and artistic works. And we'll see better how it works. So what are the intellectual property and the IP rights, though? The intellectual property refers to the creations of the mind, and the laws assure protection of these creations, conferring them some rights, which are in fact the intellectual property rights. In general terms, the IPRs confer an exclusive right, and in particular, the IPRs confer to their owner the right to prevent others to use something without his or her permission. Some IPRs need to be registered or filed, we say in technical words, like the patents, for instance, but other IPRs, like copyright, might not need so, also depending on the specific concerned law system. Okay, so we have defined what the intellectual property is and the right that insists on this intellectual property. One other important thing to know is that there are different kinds of intellectual properties, as we have already said, and different intellectual properties can give rise to different rights. And also the way the owner of that intellectual property can get the rights associated can be different from a case to the other. So here in this slide and the next one, we have a brief introduction of the main different type of intellectual property. Like we have new inventions which can be protected and give rise to the right of the patents. And to get a patent, you need to pursue an application procedure, which also get an examination from a particular authority. We will see this better in a while. Then we have original and creative artistic forms that give rise to copyrights, and they exist automatically as soon as the author has finished its own creation. We have distinctive identification of products and services, which are the trademarks, and they can be obtained through the use and or a procedure of registration. Then there is the registered designs, which is used to protect the external appearance of industrial products, and it is obtained through a procedure of registration, again, similar to the trademarks or the patent. Then we can have databases, which are the form of legal rights compared to the collection of items arranged in a systematic or methodical way. And they also exist automatically when we have realized our collection, our database, in fact. Then there is the trade secrets, also referred to as the know-how very often. And the know-how is considered to be a trade secret when the proprietor, the owner of that know-how, is able to demonstrate that he or she put a reasonable effort to keep that know-how secret, and that know-how is an economic value because it is secret, as long as it is secret, which is then being completely lost when it becomes public. And then we have also the new plant varieties, which serves to protect the new species, the new varieties of plants or vegetals, and we need to make an application to get the right. Okay, so this is a very general and quick list of the different kind of IP that exist and the rights that can be attached to those IP. Now we go into the patent specification. We will have a better look into the patent system and how we can obtain a patent and the different strategies that we can use to protect with a patent our invention. The first point is we've said that patents serve to protect invention. So what is it, an invention? An invention is considered to be an original solution to a technical problem. Take care, there is a very specific use of terms in this sentence, because when we want to have an invention, we need to have a technical problem, and we need to find a technical solution to that problem. Okay, so the logical framework to understand if we have an invention that we can eventually protect through a patent is that we start knowing what is the state of the art of that specific field. Then we can identify some unmet need, some unsolved technical problem in that state of the art, and we come out with an original solution to that technical problem. This original solution is our invention, and it can be patented only if it shows to have some specific requisites. And these requisites are mainly the three ones listed here. The invention to be patented need to be new to the world. That means it has not been published or disclosed in any form, not written or verbal form, before the date of filing the patent application, the patent request. The invention need to be inventive. That means it is not obvious for the technical expert of that specific field. and it also needs to be susceptible of industrial application. Okay, so if we have a state of the art, we find a technical problem and we come out with an original solution, we have an invention. And if this invention is new, is inventive, and is susceptible of industrial application, then we can file a patent application on it. What are the rights conferred by a patent to the owner of the patent? It's the right to prevent others from making, using, offering for sale, selling, or importing infringing products in the country where the patent was granted. So this is the full list of the different rights in legal term that are conferred from the patent. And there is also another important concept here, which is the country. So the patent is something which gives some sort of protection to the owner of the invention only in the country or in the countries where a patent has been obtained. There is an exception, of course, which is for the non-commercial purposes. So for private use or academic use, academic research purposes, we can use also patented invention, and we are not infringing the rights of the owner. These rights can be assigned to others, sold, or also they can be licensed to another party. And the time limit for the life of a patent is of 20 years. Then after the 25th year from the date of filing, the teaching contained into the patent document becomes public, and everyone is free to use that knowledge even for commercial purposes. The laws specifically states a list of exclusion from patents, and there are two main families of objects, of reasons why some things can be excluded from being patented. The first group is the list of things that cannot be considered invention, and not being mentioned, they cannot be patented, of course, because we've said that patents serve to protect invention. And we also have other exclusion which relate to things that even being considered invention are expressly excluded from patentability. Like, for instance, the diagnostic, therapeutic, and surgical methods for the treatment of humans or animals. So we cannot patent a diagnostic method so that some people could die because they are not allowed to use that diagnostic method from the owner of the patent. Of course, this is an ethical choice. How does a patent look like? This is an example. This is the first page of a patent, and you can see there are a number of different numbers, dates, and anagraphical information which are needed to understand who is the owner of the patent, who is the inventor of the invention, and some other, let's say, legal information which are very relevant in terms of the economic meaning of the patents. And then we can see briefly how does the patent filing procedure works. This is an example made from the perspective of the procedure in front of the Italian office, the Italian Patent and Trademark Office. And it all starts with the filing of a patent application, which is at the filing date, at the very beginning of this chart. Then this application stays secret for 18 months. And during that period, the owner of the patent application can also withdraw for any reason the application, so that it never enters into the public domain, so it never becomes public. And after those 18 months, the patent application is published, and it also undergo an examination from an expert of the office, which will at the end decide if the patent can be granted or not, based on the respect of the requisites for the patentability, which we have already listed, the novelty, the inventiveness, and the industrial application. So if the exam goes in the right direction and is positive, we will get a granted patent after a period which can be of approximately 2 to 4 years in front of the Italian office. But before the end of the 12th month, we can also decide to file that same patent application, or to say it better, a different patent application covering the same invention in front of an office of another country, so that we can get the patent for the same invention, also the patent protection, also in the other country. And we have to do it before the end of the 12th month. And normally, in this case, we have different choices. We can go in front of and file the application in any specific country in the world. So we can go in France, in Britain, we can go in the States, we can go in China, etc., etc., etc. Or we can take advantage of special procedures which are available in front, like for instance, in front of the European Patent Office, where we can get a European patent application and then a European patent granted. In this case, a relevant thing to know is that one application filed just once at the European Patent Office can cover up to 45 states, and this is the map of all the states, the countries that are part of this convention. And if the patent is issued centrally, then of course always subject to the examination, then it results in a bundle of national patents that we can obtain after the central examination. So once the European Patent Office tells us that our patent application has been accepted, we can go in front of every authority in any one of those 45 states and ask for our granted patent without any more examination. Another special procedure that we can use is the PCT, the so-called PCT application, which stands for Patent Cooperation Treaty. The authority in this case is the WIPO, the World Intellectual Property Organization, and in a way which is similar to the European patent, it covers up to 153 countries, which are more or less the whole entire world. The main difference in this case from the previous one, from the European patent, is that the patent, the PCT, never brings to the grant of the patent. This is just an application phase. And it gives us the right to extend that initial period. You remember the 12 initial months, the PCT basically extend those 12 months to 30 months. And so gives us more time to take a decision and to build our own strategy to decide in which states we want to go for the so-called national validation phase, which have to be to occur after the 30 months that we got passing through the PCT application. Okay, so putting together all these different procedures, we see, for instance, this is an example of what can happen when we start with a first Italian patent application. We have the first 12 months, you remember, and then we have to decide. We can go directly extending our patent application in any of the countries that we are interested, like in this case, USPTO, which is the Patent Trademark Office of the United States, China, Japan, European Patent, or other European countries. Or we can decide to go PCT. If we go into the direct state, then we will face a patent examination procedure in each one of them, and at the end we can get a granted patent in the States and maybe not in China because they rejected it, and maybe in Japan they accepted it, and so we will have a bundle of different patents, not necessarily all rejected or all accepted. Every single state can take its own decision. If we go PCT, we get some more time, as we said, and we extend our safe zone up to the 30th month, and then we will have to decide where we want to go. We can, at this point, we have to decide and to go into every single state. And if as soon as we enter into the national phase, we will face our procedure, our examination in front of the different offices. And of course, like if, for instance, we went also with a European patent application, at the end, the EPO will eventually grant or reject our patent. And if it is granted, we will have to decide if where we want to validate it between the 45 states which are part of the convention. So you can see that the picture is quite complex, if you want. There are many different variables and many different possible pathways for the protection of our patents. And this is the reason why we need to have a good understanding of this system and how it works if we want to properly protect our research results. To wrap up at the end of this session, we list the main things that we have passed by, and we will bring home as a new knowledge after this brief session. Is we understood how to explain the importance of intellectual property in the knowledge economy and the main social and economic goals of the IP laws. We understood how technology transfer activities can contribute to sustain the socio-economic development of the society and the role played by intellectual property and intellectual property rights in this regard. We now have a basic knowledge of the different categories of IP rights, and we are able to explain the function of each set of rights, patents, trademarks, copyright, etc., and their similarities and differences. We made a deep dive into the patent system, looking at its rationale, at the patentability requirements, and the main procedures for protection. And now we understand the value of the patent information as a source of technical and strategic information. So this is all. This is a brief disclaimer on the slides I just used, taking advantage also from some teaching material made available from the European Patent Office itself. And this is all for our session today. Thank you very much, and get connected on LinkedIn if you like, and if you have any question, just drop me an email or a message and I'll be more than available to answer. Thank you.